In late 2017, in the small northeast Victorian town of Tallangatta, Nadia Bash was invited to an 18th birthday party. She was 17 and hadn't had much of a social life. That night, she began chatting to two men she hadn't met before, a few years older than her, and says they were getting along well. Until later, when she says they beckoned her to an area behind a hay shed and raped her.
I told them that I don't want to do this, that I'd never done this before, and I was just telling them stop and that it hurts.
Hours later, she went to police. The men were later charged with rape and faced court in 2019. The jury found one man not guilty on 4 counts, but couldn't reach a verdict on a 5th charge, which was later dropped. The other man was convicted of one of 3 charges and sentenced to 4 years jail. His conviction was overturned by the Court of Appeal last year. Now, Nadia Bash is speaking out, not about the verdict, but the trial and the questions put to her, which she says made her feel like she may have been to blame.
I just felt like screaming to them, what has this got to do with anything? I felt even though I was a virgin, I was being slut-shamed. And just victim blame, and it just wasn't fair to me.
It wasn't just Nadia who had concerns. When the first case under Judge Richard Smith was declared a mistrial over an unrelated matter, a new trial was called. It was under Judge Meryl Sexton, who specialises in sexual assault trials. When she reviewed Nadia's cross-examination from the first trial, before playing it to the new jury, Judge Sexton struck out more than 130 lines from the transcript. She ruled they were irrelevant or inadmissible about Nadia's clothing that night and her sexual behaviour. At one point, Judge Sexton told a defence barrister,
I can't believe that in the year 2019 I'm having discussion with counsel about the relevance of what the complainant is wearing in a sexual offences trial.
In one deleted exchange from the first trial, defence barrister Hayden Rattray asked Nadia Bash what she was wearing on the night.
I was wearing boots, jeans, a belt, a leather jacket, a jumper underneath, and a top underneath that.
Can you describe the top that was underneath?
It was long-sleeved and high neckline, black.
And what sort of material was it made out of?
Sheer material.
The second defendant's barrister, Charles Morgan, further questioned Nadia and said,
So your jacket and a sheer shirt that I think people have described as being see-through, so you had under a bra or something under that?
I had something over my bra, but under my shirt, yes.
So when yesterday you just said you were wearing a jumper, was that to downplay the actual state of your dress that night?
Before the second trial, barrister Hayden Rattray submitted to Judge Sexton that the detailed questions about clothing were relevant to establishing his client's credibility with the jury.
I'm not saying for a moment that because she was wearing a see-through top she consented. I'm not saying that for a moment.
Well, that's the flavour that comes through when you read the transcript.
In other exchanges, both defence lawyers asked about an alleged conversation with 2 other girls earlier in the evening about sex.
Do you recall a conversation about whether or not you were going to get a root tonight?
No.
Can you say absolutely that that did not happen?
I can say absolutely that did not happen.
And I take it then you'd say absolutely that you did not say, I don't know yet, we'll see, I'll take what I can get.
I can absolutely say that I would not say that, because at the time I was a virgin.
You'd been drinking?
Yes.
You'd been behaving in a way that you wouldn't have been behaving had you not been drinking, correct?
I had been drinking before.
You'd been kissing a friend of yours on the lips?
Closed mouth.
You accepted that that was behaviour that you wouldn't ordinarily engage in.
Well, it wasn't sexual kissing, it was closed mouth.
In court, Hayden Rattray submitted that the exchange did not breach the ban on discussing sexual history.
So kissing is not a sexual activity?
No, absolutely not.
I'm definitely living in another universe.
Hayden Rattray told the ABC that the questions he asked were in good faith and, in his judgment, were legitimate questions asked in cross-examination. He said conversation about sex was directly relevant to the question of whether or not Miss Bash consented to sex with his client. And the conversation about clothing was relevant as to the reliability of his client's recorded interview with police. The other defence lawyer, Charles Morgan, did not respond to questions from the ABC. The judge who allowed those exchanges in the first trial has also been criticised for a comment referring to Nadia losing her virginity with a cricketing term, breaking her duck.
These types of comments are completely inappropriate. They're inappropriate in any proceedings, but they're particularly inappropriate in a rape charge and trial.
This is an issue that's been talked about for years. In May, the Victorian Law Reform Commission's chairman, Tony North, criticised what he called dinosaur lawyers, who humiliate and denigrate victims in order to break them down. It's been years since all states and territories passed rape shield laws, which ban evidence on a complainant's sexual history or reputation. And there's more change coming. The Commission is preparing sweeping recommendations to improve the way sexual assault cases are handled through the justice system.
I still get nightmares about it, feeling like I'm back there, feeling like I'm back on trial because of it, and it was exhausting. It was a really exhausting time for me.